All righty. Here we're hiring another paralegal and another leads team person.
Another leads team person other than Ariella?
Yeah. I think it's a friend of Alex's.
Oh, okay, cool.
Yeah, she had a job in a company, this company that sells online denim jeans for ladies, and apparently the lady that ran the company was very difficult, and working in the customer service was really hard because clients would get really mad and yell at her. So hopefully we won't have that. Hey everybody, as you come into the room, please go ahead and say hello. Let us know who you are and where you're watching from. We'd be glad to hear from you. Sure thing, Anna, no problem. We're going to go ahead and get started in a couple minutes. We'll let everybody, there's my man Mudassar. We're going to let everybody get into the room, and then we'll start with the questions. If you have a question, you can leave it in the chat. I'd always thought that the chat was available to everybody, but that's not the case, right? Mackenzie, just you and I see the chat?
I thought it was available to everybody.
Is it? Okay. Can you guys all see the chat? Let us know. And also, Mackenzie, I haven't talked to you about this much. Okay, good. Thanks, Mudassar. And Will, we've been, for those of you guys who are regular attendees, like my man Will, you guys know that every other week we do a webinar on lawsuits. But Mackenzie, I was talking to Laura today about maybe doing webinars on, specific topics like I-130s or naturalizations or asylum. So if you guys think that would be helpful for us to do case type specific webinars, leave us a comment down below. Mackenzie, can we see these comments after the webinar is over? That was the other question, because Laura's not going to be with us today monitoring the chat, but she'd been working since 4 this morning, so I told her to just take it off.
Yeah, we can save the chat after the webinar.
Okay, so save that for her just in case. If anybody wants to get a hold of our leads team, just leave us a note, and Laura or Mackenzie or someone from the leads team will follow up tomorrow. Before we get started, I want to show you all my new shirt. I'm really excited about it. Mackenzie hasn't seen it yet. Can you guys read what it says? I've become a sucker for buying t-shirts on Facebook. First, I bought that Chris Farley shirt when he's the guy, Matt Foley, the inspirational speaker in the van down by the river, and everybody thought that was me on the drawing of the picture. I'll wear that. And then I bought a Montreal Expos jersey or shirt because I really like that old team from when I was a kid. Now I got this one. So I think I'm starting to see t-shirt ads all the time in Facebook and Insta. Yeah, all right. So again, if you have a thought on us doing a special webinar, like say on how to get your green card through marriage, or how to get your how to get a work visa if you're on an F1, those kinds of things, let us know if you think that would be helpful. Yeah, thanks, Will. And then let us know what topics you'd like us to cover. That would be helpful. And I guess when people watch us on the replay, Mackenzie, they can leave comments in the YouTube channel down below too when they're watching the recording, right?
Yes.
And we got to tell Izzy to splice this one in someday in the next couple of days, I guess, so that that'll be our video for that day. For those of you who don't know, we've done a video, Mackenzie, right, every day since January 1st.
Every day since January 1st.
That's pretty crazy. And I know that when we started, our subscriber list was about 9,100, and now it's up to like almost 22,000.
Yeah.
Which is sort of crazy. All right. So let's get to it. I wanted to just fill you in. So I was on vacation last week in Michigan, had a great time. And when I got back, I shot 7 videos on Monday morning, and most of them were about things that had happened during the week. So those will be coming out in the next couple of days. My thoughts on recent developments, including USCIS is going to have fee increases on October 2nd. So most cases are going to become more expensive. Some, strangely, are going to be less expensive. Like to renew your green card is going to cost less money, which is very strange. So that we did one video on that. We did a video on how to handle yourself with all of Trump's different immigration bans and sort of what your mindset should be on those. I did one on what to do if you have been outside the United States on your green card for a long time and still want to apply for citizenship. I wrote up a little blog post about that today. And so there's some good videos coming out, but if you have video ideas, you can also leave us a note down below. And if you need me to go into more depth with something, happy to do that in upcoming videos. I'm going to try to, my son has taken over the editing of our videos, and so far he hasn't screwed it up too badly. Hopefully he'll continue. But I'm going to try to get ahead of, so right now I'm doing them on Monday, and we have them up to the next Tuesday. So getting ahead would be good. All right. So with that, Mackenzie, let's go ahead and get started.
All right, so let's start with Will. His question is, with the recent public charge ruling on hold in New York, does that mean if you submit your spouse visa application now in August, will you be fully exempt of the rule when going through the entire visa process?
So that's a great question, Will. So for those of you who don't know, if you want to sponsor your spouse for a green card, you have always had to demonstrate and prove to the satisfaction of USCIS or the State Department that your spouse will not become a public charge. So the public charge rule is not an old rule. It's just that the interpretation of that public charge rule has expanded. Now, the Trump administration has made lots of unilateral changes without following the rules, but one that they did follow the rules on is this new public charge. They released last fall a 900-page rule on how they were going to expand the public charge. And in doing so, they have greatly increased the amount of work and paperwork that you have to do in order to sponsor your spouse or family member for a green card or for an immigrant visa. And what Will is mentioning is that last week, a federal judge said that the Department of Homeland Security's interpretation of the rule was not valid, and the judge prohibited USCIS from implementing or continuing to use their new standard and from specifically using this form called an I-944, which is a petition of self-sufficiency. If you don't know, it's a horrible form. It's 20 pages long. It goes into great detail into the financial history, the education history, the employment history of the foreign national, and it sort of feeds into this approach of white nationalists who like to portray immigrants as lazy, do-nothing people who just want to come here and suck on the government dole. And so now temporarily a judge has ruled, and there's some confusion right now as to whether or not this injunction applies to everybody in all 50 states or just the states in the Second Circuit. And my current understanding at this moment in time is that it applies all the way across the country. So Will's question is, are we required to still file the I-944, which, like I said, is a big pain in the ass. And here's where we've come down at the office in talking this through. We're lucky in that a lot of our clients, we think, can beat public charge even under the new rule. So for those clients, we're going to still go ahead and file those applications. Now, Homeland Security, USCIS has said that they will not be looking at that 944, but the problem is that I-944 is the public charge document. The problem is that the green card application hasn't changed. And the green card application was updated to reflect the changes in the 944. And so there's a lot of questions now in the 485, the application to adjust status, that weren't there before. And so because of that, we feel that USCIS, you always have to assume that they're going to do the most evil thing possible. That even if that judge has said that they can't enforce it, that they're still going to try to come up with ways to screw people. So unless we're convinced that our clients can't beat public charge under the new standard, we're going to keep filing them with the new standard, because that ruling could get overturned, different things could happen. So to be overly cautious, to be overly careful for our clients, we're going to still go ahead and file those. Now, if you're convinced that your spouse or your family member can't beat public charge under the new standard, you're better off probably filing without the I-944 and just using the old standard, which is the I-864, which you have to submit either way anyway. So either way, you probably want some help with that. The affidavit of support itself and the I-944 are both tricky forms. So if you have questions, let us know. But otherwise, I think if you think you can beat public charge, you should go ahead and try.
All right. Krish says, I'm an F1 student and married a U.S. citizen. We filed for adjustment of status in January of 2020 and waited for the interview to be scheduled. I'm graduating from grad school now. Since we have already filed for adjustment of status, I was told that I would not be eligible for the F1 OPT extension once I graduated. Does that mean I will no longer be in status?
That you are in status and you should be getting your work card, but you should absolutely apply for OPT. Whoever told you that's a moron. So we have always told our clients as graduating F1s, that would be a good video idea. We write that down, Mackenzie. I just did a video on F1s getting their green cards based on marriage, but that issue about OPT, that would be a good one to do. That's total BS. Don't listen to whoever told you that. If you're still eligible, if you haven't graduated yet, go ahead and apply for OPT. Get that work card. You never know what's going to happen with the marriage case. You're still in status since you filed for adjustment. But I'm a big believer in taking advantage of every immigration benefit that's available to you. And so whoever told you that is wrong. And if they have any questions, have them email me, jim@hackinglawpractice.com.
Okay. Jimmy asks, for asylum in the master hearing, does the immigration officer transfer the application to the judge, or does the lawyer have to submit a new application?
You're going to want to update it. You don't have to do it before the master calendar hearing. The judge will have the file from the asylum office. So really, you're not going to update things until you have your actual trial. So in deportation, there are what's called master calendar hearings, and then there's individual calendar hearings. Individual calendar hearing is the word for your trial. Master calendar hearing is like a pre-trial docket. Now, you're going to want to make sure that you can explain to the judge why you fear persecution, and if you do want to supplement it, that is a time where you could supplement it when you file your written pleadings in the immigration court, but you don't have to.
Andy says he was told that he had an approved I-140 employment-based petition pending since 2007 when he went for his marriage-based green card interview in 2019. The marriage-based green card got denied, and he wanted to ask would it be possible to use the approved I-140 employment-based green card to get a green card. He has since lost touch with the employer who filed for quite some time since 2007.
He'd want to do a Freedom of Information Act request to see if the employer revoked it. If not, he might want to try to find an employer in a substantially similar field and see if they'd be willing to sponsor him. The I-140 in and of itself, that's 10 years old, might not be enough to get it approved. He's going to have to do some research. And that's all going to begin with a G-639, which he can file online to get him Freedom of Information Act. And he should ask for all immigration paperwork. That should be the request. And then once he gets that back, then we could do an analysis as to whether or not that I-140 is still viable.
Anna says she's under a TN visa, and she asks, is it mandatory to add the last 2 pay stubs when intending to request for a change of employer, or would the W-2 suffice?
I think you always, when you're talking about a TN and you want to have updated proof, whenever you're in an employment situation, you want to have updated pay stubs. So I would ask why you don't have updated pay stubs. That they would view that as strange. So I would say, yeah, go get them if you can.
Noah wants to know that during the process of his N-400, can he still travel back to his home country?
When I was a brand new immigration lawyer, I thought that naturalization applicants were prohibited from visiting their home country or visiting any country while their case was pending from start to finish. That is incorrect, and that I don't think I have any videos where I said that, but I certainly told clients that in the past. You can leave while your N-400 is pending. Now, the bigger question is, should you do that when things are so strange with Corona? So if you have a pending N-400, you never know when you're going to get your interview notice. So You might want to talk to people in your area. Like for me in St. Louis, naturalization interviews are, usually 5 or 6 months out, and New York and San Francisco are 12 months out. So you might be able to gauge it a little bit, but if you can get back quickly, and if you have a valid green card and a valid passport, I think a quick trip abroad wouldn't be the worst thing in the world. It'd be okay. Now, I will say that if you're from a country that the United States views as unstable, like say Sudan or Pakistan, that a trip abroad can in and of itself slow down your immigration case. That'd be another good video, Mackenzie, for us to do. How going back to visit the home country, if it's a volatile home country or one that the United States views with suspicion, that can in and of itself slow down your naturalization case. We've seen that before. I had a lady who went back to visit Pakistan. Actually, she visited between the time she got the interview notice and the time of the interview. And when we got to the interview notice in Long Island, they said, "Oh, we don't have the file." When they say we don't have the file, that's BS. That means, that'd be another good video, Mackenzie. What does it mean when they say we don't have the file? That's just cover for them wanting to do more background checks. So they were freaked out because she had gone back home to visit Pakistan sort of on a last minute flight. And then they just told her, we don't have the file.
Okay. Jay says he is currently working for one employer under their H-1B valid until 2022. He's been working for this employer for the past 4 years with an approved I-140. However, I'm in the process of finding a new job with a second employer, and they will file an H-1 extension, which is a separate H-1B application. Can I work for both employers on 2 different H-1Bs for a while, let's say 6 months or so, and then quit employer A?
Yep. As long as the second one gets approved, yep.
Abdul says, I'm a permanent resident. My parents came to the U.S. in November of 2019 and never returned back. They overstayed their visa. After I became a naturalized citizen in the next year or so, can I file for their adjustment of status-based green card?
Yes, you can, and you should.
Okay. He also asks if they leave the country, will they get the 10-year ban?
Yes, they will. So they should stay. Now, one thing that's interesting, that's Jay, right?
Yes.
One thing
Abdul.
Oh, Abdul, that's one thing that's interesting, Abdul, is that they will ask you on your N400 for the addresses of your parents. And you want to make sure that you're very honest about where your parents are. Now, I've never seen them work so hard that if someone in a naturalization interview discloses that they have a spouse or a set of parents who are in the United States without status, I've never known them to go out and look for those people. Doesn't mean that they can't, but I think it's pretty rare. They just want to adjudicate the case that's in front of them. They don't want to create a case to have to go find mom or dad. But it's important that you're honest and accurate about where your parents are, because if you put down address A for them now and then get your citizenship and then put down address B, like if you make it like they're in Pakistan when you're getting your citizenship, and then all of a sudden you're saying, or whatever country it is, then you're saying all of a sudden, oh no, they're here with me in Fairfax, Virginia, then you're going to have a problem because you've given inconsistent answers, and they might say that you lied to them at your naturalization interview, and then they might try to take away your citizenship. So you got to think that stuff through.
Okay. Camila talks about how USCIS has been kind of pulling her around. She says, my N400 interview was rescheduled from April 6th to August 12th due to COVID. I got a letter yesterday saying that my interview was being postponed again due to unforeseen circumstances. I called USCIS and they told me my application is in the local field office already there and there are no red flags. What happened there? I've read I can go to the field office anyway on the 12th just in case. Should I go?
My wife would definitely say to go on the 12th and see what happens. My question would be a couple one. Number one is, when did you file the N400? What's the receipt date? And which field office are you dealing with? Leave us that stuff in the chat below and we'll come back to this question, okay, Mackenzie? Make sure you get that person's name so we don't forget it.
Yeah. Andreas asks if a person has an unrestricted Social Security and a driver's license from the state of California, is this person allowed to work in the U.S.?
There's no. Read that again.
If a person has an unrestricted Social Security and a driver's license from the state of California, is this person allowed to work in the U.S.?
Well, the only way you'd have an unrestricted Social Security number would be from being a U.S. citizen or a green card holder. So, and that wouldn't be issued by the state. That would be issued by the federal government. But if you have an unrestricted Social Security number and a state driver's license, can you work? It depends how you got the Social Security number. I can't answer that in a vacuum unless I know more facts.
Clement says, if an F1 visa holder marries a U.S. citizen and then due to her insecurity she decides that she wants to file for divorce before filing the I-130, what becomes the fate of the F1 visa holder?
As long as they're still in school and have a valid I-20, they should be fine.
What if they're not?
Well, then they don't have status. And, you get 60 days to leave when your F1's over. So, it all depends on timing and when the school will revoke the the I-20.
Jay asks, hi, if I change my address while my I-485 is pending, do you think it'll delay my case?
Yes. But you should still do it. I will say, if you change your address within the same field office area, that won't slow it down. But you definitely want to make sure that you keep proof that you updated your address, because there might come a question. They might send an interview notice to you, and then they might send it to the old address, and then you might not show up, and then they might dismiss the case. So make sure that you send it by Federal Express or do it online and keep the confirmation so that you have proof if you ever need it that you followed the law and updated your address.
Nadidi asks, I heard that the Nigerian embassy is keeping normal processing of immigrant visas closed until December 31st, which is the initial proclamation date. Are they able to do this despite it not applying to actual spousal visas?
I would say that if that's true, and if someone could prove it to a judge might be interested in that. If it's based on COVID, I think a judge isn't going to get too interested in it. But if it's based on illegal interpretations of the presidential proclamation, that's something that you could challenge.
Okay, Madasser says, I got a notice of intent to deny on an I-130 after filing a lawsuit which was pending for 2 years. NOID is filled with lots of things, which is not at all true. I have solid documentation and answers for their questions. Do you think we can overcome this NOID?
Yes, Mudasser, we wouldn't have taken that case on if I didn't think we could win it. So my wife, Amani, and my colleague, Laura Vagley, have gotten very good at responding to these NOIDs and these RFEs that come out after a lawsuit's been filed. So, yeah, I mean, every case is different, but I would say that, knock on wood, the majority of the NOIDs that we've received after suing them have all, those cases have all gotten approved, I think. Maybe not one.
Ayeli says, I understand that not all asylum-based I-485 applications are called for an interview before their case is adjudicated. If you are in fact called for an interview, what questions do you think the officer will ask, and how best could you prepare?
So the best, that's a great question. Good video idea, Mackenzie. So when you receive asylum in the United States, you are allowed to apply for a green card based on that asylum grant 1 year later, 365 days after the asylum case was approved and the I-94 issued. Historically, what's this person's name?
Ayeli.
Historically, most asylum-based green card cases had no interview. It's only been under Trump where we've seen more and more of these interviews. Now, I believe everybody's getting an interview. And here's the thing. Up until about a year ago, the asylum office was kept very much separately from the regular USAS office. Now they're sharing all that data and that information. So, in answer to your question, if I was applying for a green card and I had received my asylum, I would make damn sure that I have a complete copy of my asylum application. So the way to do that is to file a Freedom of Information Act with the asylum office or get it from your lawyer if you had a lawyer. You're going to need to know the facts of your asylum case because, in all honesty, the current administration's interest in conducting an interview on your green card is probably 10% to give you the green card and 90% to catch you in a lie to try and take away your asylum. So I might argue that if you've been given asylum in the United States, you might, and it's time for you to apply for your green card, you might, one, definitely want to get a copy of your file. Number two, you might want to wait to file to see what happens after the election, and you might want to wait a little bit after, if Trump loses, to apply so that your green card case is treated fairly and not like these fishing expeditions that they're using for it now.
Dan says, I'm a U.S. citizen and I was, sorry, I lost that question. Hold on, let me find it. I'm a U.S. citizen. I was married in January 2020 and my wife is a French citizen. And we're doing the application process for her 2-year conditional green card. We're trying to figure out how it'd be possible to live in France. However, we've been told by people that it's not possible to stay abroad for more than 2 years. I'm not U.S. military or government employee, neither is she. Is it possible to live abroad and maintain the green card process?
Well, I mean, to me, I would say, well, this is contrary to federal law. So if you'll remember, the name on the top of the card is permanent residence card. So a green card is not a way for your spouse to enter the United States more easily. And the United States, especially right now under President Trump, hates immigrants and they love everything they can do, doing everything they can to try to screw over immigrants. So I think you're just inviting trouble by trying to stay outside the United States. I would say either don't get the green card in the first place or, ask, why are you doing all this if you're not planning to live here? Now that you've gotten the original 2-year green card, I think you need to do what you can to protect it. And I would encourage you, if you really do want to go live in France, wait 1 more year, apply for citizenship, and then she can go live wherever she wants.
Jimmy asks, how long in an estimated time is there from the master hearing to the next appointment? At least how long does it take for the immigration judge to make the next appointment? Does it take weeks, months, or years?
Yeah, and Jimmy had another question too. I saw it in the chat about whether or not the judge could decide your case while in between your master calendar and the trial. So let me just walk everybody through. So if you're an immigrant in the United States and the government decides that they want to deport you, they're going to hand you something called a notice to appear. They're going to mail it to you. And on that notice to appear, or shortly thereafter, you're going to get it'll have a court date on there. And if you ever want to know your court date, you can always call this number, 1-800-898-7180. And you can hit 1 a few times, and then you put in your alien number, and it'll tell you when your next hearing is. And like I said earlier, your hearing will be either a master calendar or an individual hearing. So right now, it's so ironic. The Trump administration was trying to clean up and speed up the asylum docket, but because they've been so harsh in other areas of immigration, the immigration courts are more backlogged than ever. So right now, we're seeing people get their master calendar hearing, and then they get their individual hearing 3 or 4 years later. So you're going to get your initial court date, which is your master calendar, and then you say to the judge, Judge, this is the defenses that we have to deportation. My client wishes to file a claim for asylum withholding or protection under the Convention Against Torture, or whatever other defenses that you have. And then the judge is going to give you a date, like I said, 2 or 3 years out. Now, here's the thing. After the judge closes your file on your day of your master calendar, no one's going to look at your case until the trial date. maybe a week or two before. But these judges and these attorneys for the government are so backlogged that no one is spending time thinking about you until they have to, because they have so many other cases ahead of you. So you can't put much stock in it. Nothing's going to happen fast, and you're going to be waiting a really long time. For me right now, if my clients have a chance to have their cases delayed at least until after the election, that's a good thing. So I'm not complaining.
Okay. All says, my husband has taken the citizenship test 5 times and he has one this Monday. Every time he goes to the interview, it's like he forgets everything and seems to fail. Is there a way for me to go into the test with him so he's not so nervous?
You can ask the officer, but they're probably not going to let that happen.
Leanne asks if your I-751, in one of your videos on YouTube regarding the I-751 application, that you mentioned that you have your own unofficial checklist for the I-751 that is available if I request it. Where can I find that checklist?
Oh, yeah, here, I'll put it in the chat again. You can go on to the next question. I can listen and find this thing.
Okay. Krish says, I'm married to a U.S. citizen. If my F1 expires and becomes out of status, is it possible to use the EAD card while we are waiting for the green card?
Hold on, I lied again. I can't do both at the same time. What was the question, Mackenzie?
Krish is married to a U.S. citizen. She asks if my F1 expires and I become out of status, is it possible to use the EAD card while we're waiting for the green card?
Yeah. Sure.
Okay, I'm not going to be able to pronounce this one. It's Ogunkanbi.
Let me get this one real quick, and then
Okay.
maybe I can find it in the chat. Is it real long?
No. It's about 11 up from the bottom.
Okay, hold on. All right, so there's that. So let me... Drop it like it's hot. Uploading. All right, so everybody, this is our evidence of shared life, joint marriage together. Here you go. There it is. Okay, so hold on. Chat. You said it's about 10 people up?
Yeah.
Starts with a O. Oh, yeah. Ogunkambi. As a Nigerian, I can't apply for a fiance or spouse visa. That's true. Also, I had an F1 visa denial this morning in Finland. What are my chances to be with my U.S. fiance? Does that mean I have to give up on my fiance after 9 years in a relationship? Well, first of all, there's been a lot of confusion lately, Ogunkambi, about fiance visas. If your loved one, your partner, is a U.S. citizen, they should be able to file an I-129F, and those visas should still be being issued. I would sue over that if they didn't, but the ban doesn't apply, I don't think, to non-immigrant F1 visas. I don't think. So that'd be a conversation worth having, but the question would be if your significant other is a U.S. citizen or not, because green card holders can't file a petition for a fiance.
Clement asks, what is an alien number, and do F1 visa holders have alien numbers? If yes, where can I find it?
F1 visas are non-immigrant visas, so F1s do not have an alien number. If they get OPT and they get a work card, they'll get a USCIS number, but I'm 99% sure that's not an alien number. It's just a different number that USCIS uses. So because a F1 visa is a non-immigrant visa, there would not be someone who would receive an alien number.
Dan talks about the prereq for naturalization of U.S. citizens being a lawful permanent resident or green card holder before. Does the clock start ticking on the receipt of the green card, or does it start from the submission of the application?
from the date on the green card.
Latasha says, I applied for my IR-1 visa and my case is now waiting for an interview at the National Visa Center in Lagos. I was approved 11/14/2019, so November 2019. What do you suggest I do now?
Gotta wait. Is that a spouse of a U.S. citizen?
It's an IR-1 visa, I'm not sure.
Yeah, that's a spouse of a U.S. citizen. Yeah.
Jimmy asks, is it convenient to ask the immigration judge to transfer my case from Kansas City to Chicago?
It's not hard. I think you might need a lawyer to pull it off, though, just because there's pleading requirements. But as long as your case isn't set for trial tomorrow, you know what I mean? Like in the next couple of weeks, you should be able to transfer it as long as you have in fact moved.
Florin says, I was married in 2016 with a U.S. citizen. I filed for removal of conditions together in July 2019.
Okay.
Unfortunately, while the case was processing, the U.S. citizen divorced me in May 2020 before I received my permanent resident card. However, with nothing else done for me, I got my green card in the mail with no interview. I met my current wife and we have a baby on the way. I married her on August 1st, basically 2.5 months from my divorce. We applied for her green card through family-based LPR.
No. You can't do that. They will hit you with a fraud application they'll take away your green card. You've got to stop that right now. If you file for a green card for a spouse less than 4 years after you get a marriage-based green card, it's presumed fraud. You've got to withdraw that bad boy right now. There's lots of problems. I thought you were going to ask me about whether there was problems getting the 10-year green card after the divorce, like if USCIS didn't know about the divorce. We've had that issue here. Whoever this brother or sister is, they need our help. That's a big mess. Ooh. Mm-mm.
Her question was, do you see any challenges? So I guess you do.
Yeah, big ones. I remember when I found out about this rule, because some guy had basically done the exact same thing, and I was at home looking in my immigration nerdy law book, and I was like, whoa, I didn't know about this. This was 12 years ago. That's a real big deal. They will take your green card and deny your spouse. That's a big old mess. Sorry to freak people out, but that is not good.
Randy asks, is it normal for processing times at the field offices to go back in time? For example, in Potomac, once they were checking cases from October 24th, 2020, and now they're back to July 24th, 2019.
Yeah, that happens. They're a bunch of liars. You can't believe anything they say in those date updates, what's their binding date or what their processing time. That's all BS. I don't believe any of it. You either have the immigration benefit you asked for or you don't. That's it.
Andy asks, do you have any idea as to how much time it is taking USCIS to decide on appeals for the I-130 denials these days?
Yeah, I saw that question come through the stream. I don't file I-130 appeals. They're a waste of time. They're not ever going to rule on it. They're not going to reverse it. If you're still married, you need to file a new, better I-130 with a lawyer who knows how to put the case together. That's your much better option than filing an appeal, unless it's something very perfunctory, like they sent you a request for evidence for your medical or something and you didn't submit it. But otherwise, you're much better off starting over. Ogukambi, we spent a lot of time on your answer. Everyone's going to get a recording of this emailed to them. So we did yours probably at about the 35-minute mark. So when this comes to you tomorrow by email, you can go back and play that again. Krish, I don't care what that lawyer says. They're morons. Krish is saying that an attorney website says that filing a 45 makes you ineligible to receive the F1 OPT. Yeah, maybe, but everybody I know has gotten one, so I wouldn't spend too much time thinking about that. See if you can find Camilo's question. Camilo's asked a few times. Chris, those questions you're asking me about your H-1B, you need to like those are messy. I can't give out advice like that on a webinar like this. Those are real life questions about. I mean, I know these are all real life questions, but that's what you're trying to pull off. Work for 2 employers at once on an H-1B during your grace period. I think that you need to really rethink what you're trying to do. You need to focus on one, get back in status, and then you can talk about the other one. I would not file 2 H-1Bs for 2 employers while I'm in the grace period.
Camila's question was the N400 interview that was rescheduled from April 6th to August 12th and then rescheduled again. And she asked if she should go to the field office on August 12th.
All right. So first of all, you're suffering from Mona-itis, Mackenzie, because Mona always gets people's genders wrong. And Camilo said, "Hey, it's no big deal, but I'm a dude." So what's Camilo's question?
I always do that. He asks, my N400 was rescheduled from April 6th to August 12th due to COVID. I got a letter yesterday saying my interview is being postponed again. I called USCIS and they told me my application is in the local field office already and there are no red flags. Can I still go on the 12th anyways?
Yeah, and I said, yeah, I would go. I would go and just see what's what and then try to get some answers from them and sort of play dumb and say, hey, I'm here. Can't we just do it? I would never have done that, but my wife does that sometimes, and it's worked 3 times, so you might try it.
Oh, I also missed this one from him. It was right after his first one. He says, I also submitted an I-130 for my wife who's in Colombia right now. After getting my citizenship, hopefully I will. What kind of time frame am I looking at for my wife to be here in the States?
Yeah, so, and Camilo, I just saw in the flow that Camilo filed the N400 on February 3rd, 2020. So he actually got his interview notice really quickly. I wouldn't sweat him too much. I mean, if you get your citizenship within a year of filing, that's pretty good. So I'd go there on August, but I wouldn't be all mean or anything. I just try to be nice and see if I can get something going. Now, as far as if you have an I-130 pending and you filed it as a green card holder and you become a citizen, your priority should change and go faster. But in my experience, it actually confuses them. And right now, the cases for green card holders are current. So I might just gently tell them that I became a citizen, but I wouldn't make a big deal out of it or ask them to treat it any differently. I would just notify them and then let it play out. You're probably going to be just like everybody else who's trying to get spouses over right now, which is about 14 or 15 months. Oh, I guess, no, I take that back. You do need to notify them because of that asshole Trump and his proclamation that the spouses of green card holders can't come. So you are going to need to notify them. We're fighting that out right now in 2 of our lawsuits and with the embassies, trying to get them to acknowledge that the proclamation doesn't apply to people like Camilo's spouse because Camilo will be a citizen. Sorry, Camilo. I sometimes I forget how stupid Trump is.
Go ahead.
No, it's all good. I just, any chance I have to bash on the big orange Cheeto, I'm happy.
Yep. Abdul says, my brother's a permanent resident. He's been outside of the U.S. since February, and there's no chance of him returning to the U.S. until at least December due to the current situation. Just a small understanding of his background. He has a full-time job in IT working remotely. He's renting a townhouse in the U.S. and has paid taxes regularly. Do you think the 10 months of staying outside the U.S. will affect his continuous residency for naturalization?
So yes, I do. It could. Remember, if they can interpret things one way in favor of the immigrant, one way and not in favor of the immigrant, they're always going to figure out a way to try to screw the immigrant. So I think the important things are, and I have a video on this that you might check it out. I did a video for immigrants who are stuck inside the United States and can't get out because of COVID, and ones who are stuck outside the United States and can't get back in. Number one, push every potential client as hard as I can to get their ass back to America. So I have seen people get back during COVID under extraordinary circumstances. So unless you can absolutely prove to me that that it's actually impossible for you to come back, I'm not going to believe it, and I'm going to want your butt back here before 6 months. Number two, if you can't get back and you want to be able to preserve your continuous residency for purposes of citizenship, you're going to need to document the crap out of everything that you did to try to get back. You're going to have to show, I called this airline this day. I bought a ticket this day. It got canceled this day. You can't just say, oh, woe is me. I'm stuck. We're working remotely back home. I can't come. If you want to be able to prove it, you're going to have to document the crap out of every effort. You should just keep a log of everything you did to try to get back before the 6 months are up. I think I got time for about 3 or 4 more questions, Kenzie.
All right. Let's go to Krish. She asks, if you can please explain the difference between a marriage-based EAD card and an F1 OPT-based EAD card.
Well, the only difference, I guess, would be that if you have an OPT card based on a work authorization card, an employment authorization document, a EAD, which you get by filing an I-765. If you get one based on OPT, you're only allowed to work at the employer listed on your I-20. If you then get a marriage-based EAD based on a pending green card, a pending I-485, you can work wherever. So you could work for that employer. You could take a second job at Walmart. The only thing to remember is that you want to make sure that your marriage case is going to be approved, because once you work on your EAD based on marriage, that's a violation of your F1 status, even though you have work authorization. So it's sort of tricky if you do that. So you want to be careful and make sure that you only do it if you have to.
Mm-hmm. Leanne asks, is it normal to not receive any notification from the Department of Homeland Security as an alert when to file your I-751? I was seeing online that some have received an official notification when it's within the 90 days period before the expiration to file, but we haven't. Just wondering if you've seen those notifications before, or if it's normal not to get them.
Good YouTube video for us, Mackenzie. I would say that about 40% of our spouse-based cases get that 751 reminder. So I would think it's more likely than not that you're not going to get it. And that's especially true if you've moved. So the only red flag going up in my mind on this question is make sure that they have your most current address. They say that they send it out in every case, but they don't. So, it's your obligation to maintain your status. Sometimes even have you sign a form at your green card interview that you're going to file that 751 and that they've been made aware of it. But that mailing that you get is sort of hit and miss.
Mm-hmm.
Camilo, I don't believe anything they say about unforeseen circumstances. I think they're probably sitting on your case. And so, it could be Corona. It could be that they thought there was going to be a furlough. Just wait and see what happens. I wouldn't read too much into it, and I certainly wouldn't feel bad about it.
Mm-hmm. You want to do one last one?
Yeah, 1 or 2. All
right. Narsimha just said, I work on H-1B from 2008 to 2018 under the same employer. In 2018, for an H-1B extension, I was denied. I have an approved I-140 from my employer. After my extension got denied, I moved to old third-party client for a new project and reapplied for an H-1B extension, but I was asked to prove my legal status of being in the U.S. after the extension had expired. I guess, what can she do now? Or what should she do?
Yeah, that sounds a little bit messy. We've been suing the crap out of them for wrongful H-1B denials. I don't know the time frame of yours, but you might want to think about suing them to get those reversed. We've sued them like 15 times, and they've reversed themselves every time. So I can't tell from Narsimha's answer or question the whole end of it. But it does sound like there might be a time period of out of status, and so that can be tricky because right now you can't get an H-1B stamp. So I would say this person's at a point where they need to talk to a lawyer who knows what they're talking about. Jimmy sure has a lot of asylum questions. Jimmy, watch all of my asylum videos. You'll get most of the answers to your questions. Number 2, if you want to get asylum, you need a lawyer. It's going to be hard to get it without just by yourself. Number 3, you keep asking me about this human rights organization letter, and I get that. It's okay, but it's not going to be enough. I think you need to really beef up your case. That's good evidence, but it's not going to carry the day in and of itself.
William asks, will USCIS reject the I-485 if the pay stubs are not from the previous 6 months?
I'm not sure exactly what kind of 485 William's asking about, but I would always say that if there's something on the list of things that they want, you always want to do that. So you always want to give them what they ask for. Let's finish with Jay. I guess there's two. We'll do two more here. Let's do Ayel and Clement. If you want our attorney's fees, just call the office 314-961-8200. They'll tell you all the fees. If you ask us what kind of if you tell us what kind of case it is, they'll follow up with you. Narsima's calling me out saying that she calls our office and we don't call her back. So let me see. Old Narsima's in the system. Do you want to ask me those last two real quick, Mackenzie, while I do this?
Sure. The Ayeli and J.
Yeah, that's a good one. Then there's a little one underneath it that was sort of short.
Ayeli says, my first question is that even if my asylum grant was on political persecution in my home country, but recently the party has been dissolved, will that potentially cause any problems for my pending green card application?
Yep.
If I was in this situation, will I still meet the legal definition of a refugee and therefore eligible to adjust status?
Wait, they already got asylum?
Yes, I think she's getting the green card now.
Yeah, I would encourage them to wait to file for that green card until after the election to see what's what. All right, Narsima, I looked you up on our system. You did call the office. It looks like you were just asking about when this event was, and we gave you that information. So I see a little bit of information about your case. I will tell Layla to follow up with you. Layla is one of our leads people, and I will ask her to follow up with you tomorrow.
All right, last question.
Yep, go for it.
Jay asks, can I switch to an EAD while on an H-1B? I have a family-based I-485.
Yes, you can. Again, you want to make sure that the family-based application is going to get approved, because otherwise working on your EAD would be a violation of your H-1B. All right, so do you want to give everyone our contact information?
Sure, I'll put it in the chat. Okay,
great. It was great seeing everybody. I always enjoy doing these. We'll do another one next month. As always, if you have more questions, Jimmy's trying to get us to do asylum pro bono. No, Jimmy, we can't represent you pro bono. We got too many pro bono cases right now. Camilo, I'm glad that you feel better. Don't give in to those suckers. They're just trying to screw with you. Your case is fine. You're going to get approved. You're going to get your spouse here. I wouldn't worry about any of that stuff. You know, I was talking to my daughter's softball coach yesterday, and he said, you know, people are just tired of bad news. People are just tired of bad news. And I think that's true. And so I always try to tell these client success stories and other victories so that you guys can keep hope alive. I want you all to stay positive, to do what you can, to recognize the things that you can change and the things that you can't. And we'll always be here for you. Dan, that's not even funny. Trump's a chump and he's a loser. And I'll be glad when he gets frog marched right into a courthouse for his tax evasion and his bank fraud. But anyway, yeah, I know, Camilo. I know it's hard. I know it's hard. But hang in there. You're in a great spot. And the good part is, Camilo, that you have a path to have your loved one here. Some people on here don't have a path right now. They're stuck with that stupid proclamation. So at least we got that. All right, everybody. I'm out. Bye, Mackenzie.
Bye.